Greetings and welcome to a brief history of AI and law and the digital transformation of society. So, we're going to learn about some things you probably didn't even realize because it's kind of like walking in the middle of a movie theater, and while the movie's halfway over, is about what we've been told about a lot of what's gone on behind the scenes. But today we're going to look at some pretty interesting text that will give us an update where we're going and also a brief history of where we've been. With that said, just remind everyone this is strictly for the educational entertainment purposes of the YouTube channel and broadcast, not to be used, misconstrued, or abused for anything legal, lawful, personal, private, business, tax, financial, or otherwise. Please don't do this at home. That said, let's get started. So let's zoom this in a little bit here. Okay, so getting back to where we're really starting with this is really in the 1970s, but the term AI really started back 60 years ago, or more than that, really, since the 1950s. So the interest in AI in the legal sector has really shown an exponential growth lately, though. So that's why we're talking about it in this presentation here. The development pattern, though, has been cyclical, not linear. So there's just been periods of dormancy followed by rapid development. But our current status, as I'm sure many have seen, is AI is on an upswing right now. The primary driver of this, improved AI capabilities, enabling sophisticated legal tools within digital transformation. So, as you know, that T in GPT stands for transformer. So let's get further into this now. Let's look at some of the terminology we'll be looking at here. And I kind of gave this kind of a 1980s DOS theme here, just to keep along with the time frame of where we're starting here, really. So the definition here of artificial intelligence for our purposes here is really an umbrella term, and it captures multiple technologies capable of performing tasks. This is an interesting part here is multiple technologies capable of performing tasks, which, if done by humans, would be considered evidence of intelligence. Okay, so keywords. Let's continue here with intelligence characteristics with a human reference. Here are some things we associate with intelligence regarding humans. We have language use, the ability to adapt, consciousness or consciousness, ability to reason, which involves logic, of course, and the ability to learn, and the ability to abstract, to know things without their full, all their substance there, and self-awareness, which is kind of a bit of a circular reasoning here, but nevertheless, these are what we consider characteristics. These are not a thing, but they're not nothing. So they're all something, but they can't really be pointed to easily. So these are characteristics, and with a human reference. Then the term algorithm. It's a sequence of instructions telling a computer what to do. And that came from Pedro Domingos. All right, we get the terminology out of the way. Let's look at some of the timeline now of the AI development from the 1950s to 2016, which is the date of this text. So this is 1950s where we heard Alan Turing with computing, machinery, and intelligence, and he put forth that Turing test that we hear about so much today. In the 1970s, though, as we first saw the research field of AI and law established. There were early expert systems, called them expert systems in the 1970s. There was Taxman and Prolog-based systems. Then we had somewhat of a lull, at least in the popular sphere here, until 1997, when IBM's Deep Blue defeats Garry Kasparov in chess. That was a big milestone in computational power because Garry Kasparov was a world chess champion, and the computer beat him. Then in 2011, another big milestone was when the IBM Watson wins the game show Jeopardy! And that was the first achievement of the natural language processing, meaning it could hear and listen and process language into its instructions or algorithms. Then in 2016, there's the DeepMind AlphaGo. It defeats Lee Sedol in a game called Go. It's a Chinese game, actually an ancient Chinese game, but it was a learning breakthrough because not only did the AlphaGo Zero, which was the one that came after that, win at that Go game, it also won at chess, but it taught itself. So that's a big learning breakthrough for machine learning. But does it really demonstrate intelligence? We'll find out. Let's look at the classifications of AI types. Before we go any further, I just wanted to remind everyone that we do have, I believe here, the talking chat enabled. So if you type anything, comments, questions, or any other things you want to add to the presentation here into the chat, it should read it back.
The crime says, hit the like.
Yes, indeed. So there it is. And then we can respond appropriately to any comments or feedback we want to do along the way here to keep this presentation interactive. And make sure you stay to the end because there will be a special surprise at the end for those of you who stay. So let's continue. Categorizing these AI systems, we have different kinds here. We have the type of strong AI, which can reason independently. There's weak or soft AI. So this mimics human thinking without actual reasoning. This is our most current applications, believe it or not, which we call a weak or soft AI. Then there's narrow AI. It's specialized for specific tasks like playing chess or the game Go or legal research. This is the current state right now. Then there's the general AI or the artificial general intelligence. It can perform varied human activities, and apparently it's not yet achieved, at least as of 2016. And then there's the singularity, which is the machine superintelligence, which is theoretical. So right now we're concerned with what's at the current state. We know it's an accelerating growth. It's the field of this narrow AI, which is specialized for specific tasks, including legal research. Now, most current applications right now are using weak and soft AI. It mimics human thinking without actual reasoning. So let's consider that as we continue. Here are the requirements for artificial intelligence. This is the Russell and Norvig framework. First, thinking humanly. So we want to have a cognitive modeling, mimicking human thought processes. Second is acting humanly. So the Turing test, can humans be fooled? Then 3, the thinking rationally, the laws of thought, logical reasoning. That's usually a pretty easy one for computers. And then 4, acting rationally. That's rational agents acting to achieve the best outcome, which involves more of that fuzzy logic or defeasible reasoning. So each approach does require different evaluation methods, so there's not a one-size-fits-all. So let's look at this concept, soft AI versus human reasoning. So soft AI is outcome-focused, not process-focused. Think of that now. So where have we seen this before is that things like Bankruptcy Act was an outcome-focused, not process-focused. An example here, though, in this presentation is chess playing. We have a human player versus the AI system, Deep Blue. With a human player, they have strategic thinking, pattern recognition, intuition, and limited calculation, because you can only do so much before you have to make that move. But the AI system can calculate all the moves, all of them, not just strategic. He can calculate all the moves and then do a mathematical analysis and make a probability inference using brute computational force, not limited calculation. So for all these things we have, for a human player, there's pattern recognition, which is what we do. And for the AI to do pattern analysis, it needs to do it mathematically. Whereas we have intuition, which might not be objectively pointed out or explained. The AI system has to have a way of making a probability guess at what its right move or what its wrong move would be. And of course, that brute computational force is it's a lot to go against for a human with limited calculation. So our key insight is that AI doesn't think; it breaks down complex intellectual tasks into computational steps, algorithms. Yet it can act autonomously by itself and adapt to its environment better than a calculator. So a calculator or a regular computer can do that, but the AI can do it on its own and can adapt to its environment. Just because computers cannot yet think does not mean they cannot perform some tasks better than humans. So this is the key word we saw before, tasks. So here's a case study. Here's the AlphaGo Zero evolution. So AlphaGo Zero is a reinforcement learning breakthrough. The input was only the rules of Go, which is an ancient Chinese game, like I guess chess. I'm not a player of Go. The method was a self-teaching, though, through reinforcement learning, playing against the original AlphaGo. This is the AlphaGo Zero. So it learned the rules of Go by playing against the original AlphaGo, which was like the deep whatever blue think the one that beat Gary Kasparov, but the Chinese version beats their best players in Go. But then they put this AlphaGo against this new one, AlphaGo Zero, and the result is the AlphaGo Zero mastered Go and chess using the same method, just learning from watching AlphaGo. So Bradley Wendell observation here is unlike Deep Blue and the other brute force systems, Alpha Zero or AlphaGo Zero, whatever, the zero one, it played intuitively and beautifully with a romantic attacking style. That's a lot to say for a computer playing a game. But Gary Kasparov said the computer developed its own style, not that of human programmers. I don't know. He has a very high opinion of human programmers here, but it wasn't the style of human programmers playing chess, that's for sure. He said it was a style that reflects the truth about chess. So, pretty good computer there, I'd say. Now let's look at the AI branches, especially the legal applications here. So, AI, or artificial intelligence, is an umbrella term and encompassing multiple branches. So the ones that are relevant to law are the expert systems, machine learning, natural language processing. So the expert systems are the rule-based reasoning based on whatever the expert is or whatever the line of work it's doing there. The machine learning is essentially it's pattern recognition and prediction based mathematically, of course. And the natural language processing is the ability to use and construct regular natural language terms in its processing. So the other branches that are very limited in legal application currently, but you'll see actually we will go over some of this, is robotics, computer vision, speech functions, and that involves things like the voice processing, image recognition, and physical automation, which we'll get into too. So here's a quick way to look at the umbrella here of artificial intelligence, and you can see over here with machine learning, supervised machine learning, deep learning, and unsupervised, such as with the AlphaGo Zero. Those are all aspects of the machine learning part of this umbrella that we're concerned with legal applications here. The vision ones, image recognition and machine vision, that would be not primarily. The planning aspect of it, perhaps in some ways, robotics, not so much. Expert systems is definitely an area that we will be addressing. The speech to text and text to speech are again auxiliary functions, But then there's the natural language processing, the question answering, the content extraction, and the classifications, and basically making the text generated. That's all things that we're going to be looking into there too. All right, so now we get the umbrella here. You can see how the umbrella is of artificial intelligence and how it touches on all these other aspects here. But let's get back to AI and law. Here are the research field origins. Now, this might surprise a lot of people. Like I said, if you're just finding out about AI, you're walking into the movie theater, the movie's almost over. So, like anything else, throughout that movie, there's been ups and downs, as we see with the cyclical developments of AI. And coming in right now at the climax of the story here, and we're watching it happen right now. So it was established back in the 1970s, the AI and the law. The definition was a branch of AI focused on designing computational models that perform legal reasoning. So Suskind's categorization was a pragmatic system, one that can be operationalized and commercialized with practical legal applications. This was established in the 1970s. Then there was the purist research. The goal was to clarify the nature of legal reasoning, understand human and artificial intelligence, and to develop computational models of law. Many projects address the purist goals without necessarily generating practical applications of. So we had a lot of different systems being involved in that time of the 70s into the 80s. As we'll see here, the knowledge systems. Let's look at the classification matrix here first. The source here of things like hand-coded knowledge programmed by people, and then you have the statistical reasoning and causal reasoning here. So for hand-coded knowledge that's programmed by people, it's reasoning by association only. The knowledge is limited to what the human can encode. So this is where you have teams of experts or professionals setting up the algorithms. It cannot learn from new data. It has to be programmed. The causal reasoning is sophisticated reasoning. It understands cause and effects between the variables, and it can answer interventions and counterfactuals. So the very basic kind of the cause and effect reasoning here and statistical reasoning is very limited because it can't learn. It's very limited as far as statistical reasoning by what's fed into it in that data set. Now, on the data learned knowledge, that's learned from data. This is the trained type of models here. This is the data learned knowledge base. It builds reasoning by association. These are these ontologies we speak about. The predictions are based on patterns in data. May miss relationships the human encoder would see. Of course, that's due to experience, right? And knowledge that's pre-existing, that's programmed. So that's what the data learned knowledge models might miss. However, when it comes to the causal reasoning, the cause and effect here, the data learned knowledge is the most powerful option. It combines the causal reasoning with the ability to learn from data. And this is the future of legal artificial intelligence. This came from the University of Melbourne Network Society Institute. So this is a pretty good classification matrix to see the difference in the different knowledge systems, the hand-coded knowledge or the data learned. So by using rules and algorithms, it starts to learn its reasoning by association of what it's learning and make its predictions based on that larger data set that's ever evolving. However, again, that may miss relationships that would already have been known that it hasn't perhaps learned yet or may never learn because of it being somewhere buried in the past knowledge. All right, let's continue. So the early systems were rule-based reasoning. The concept here is that law is a programmed set of rules. The expert components involve the knowledge base, the facts, the rules, and the relationships. But then it's represented in a symbolic form, and of course domain specific, depending on type of law you're doing there. The inference engine, the one that's going to be making the decisions here, is programmed to manipulate the knowledge base. but is basically if-then conditional statements following logical reasoning path. And of course, this is going to be a much more formal type of logical reasoning that's built in because, as is with formal logic, it's a symbolic form. Now, the famous early examples, and this is in the 1980s, we're still in the 1980s here, was Taxman, which was a tax law reasoning system, the Prologue system, which was immigration law over at Imperial College developed, and RAND made the product liability settlement recommendation system. So we had some companies, we had some software out there back in the 1980s already dealing with AI and law. Let's continue. So here's the expert system logic flow. The Waterman and Peterson system. This is the product liability in California. You start with the rule structures. We saw here this is using the if and then. So we're saying if a victim uses the product, right? And the victim's use of the product was foreseeable.
Reagan Jones, 4492 says what you put is what you get out. Many are of unsound mind, and as an indigenous one, this is more like wicked ways of invaders, strangers to obfuscate with cousinage and parody corrupt ways at play.
Yeah, well, there's some very strange aspects to this. However, the best way of knowing how it's being done is to look at the history of how we got here and where it's going. And that's all this is here to do, is to really put forth, I guess, a part of a brief history that's often overlooked and leading to a lot of things where you could say a lot of misuse of these tools. However, I digress. But thanks for that feedback there. It is very you know it really hits to the heart of this, I guess, and the humanity of it all, because we're going to get to more of that as we move on. I just want to get through these basic systems here so we understand the foundations of what we're dealing with. So on the expert systems, which is essentially what the AI legal systems will use, we have the Waterman and Peterson system here, which is a rules structure. It's using that if-then. So if the victim uses a product and the victim's use of the product was foreseeable and the product use was reasonable, follow the package directions, and the victim used the product and the defendant manufactured the product, then consider strict liability claim. So the process here, human expert creates the network of queries. So this was done by a human. The system asks the questions, it moves through logical problem, and it generates a scripted output. This is also called knowledge engineering or expertise modeling. There you go. Those are some good terms right there to know, but a very primitive system. Let's move along. Then we have the case-based reasoning. This is now in the 1980s. And it basically would reason with past cases and analogies of those cases. So I guess having abstracts of the cases ontologically related and reasoning based on that. So the goal was to determine if fact patterns are legally similar to existing precedents. So by mapping and classifying, you're able to find alignment between past cases where there was reasoning for that line of facts, or chain of facts, I should say, and if it would fit in a particular case you're doing now. But then you have the hypo system here. Let's look at these. A domain was trade secret misappropriation. So it would be very domain specific. Like we said, it would be tax law, immigration. This one is trade secret misappropriation. It used legal factors to model existing cases. And the factors given context-dependent weight. So not necessarily the specific facts of this case, but the context-dependent weight. So it's weighted heavily on context, not necessarily the exact facts of that case. The process was to find relevant precedents, then compare them to the facts. It was later renamed factor-based reasoning. Okay, so it used to be called case-based reasoning. Now it's called factor-based reasoning. So that was in the 1980s with Kevin Ashley. Then Cabaret in the 1990s was the first hybrid system. This integrated that rule-based system we saw with the ifs and the thens and this case-based or factor-based reasoning approach. And it could switch between the methods as required. So it bridged the logic dialectic separation. So here we have the formal and informal logic, but still with the dialectic, and bring into a hybrid approach that could use both of them and switch between with a flexibility. So that was the 1990s, and that system was called Cabaret. So let's move along here and look at the system limitations. These are for our expert systems, domain specific. So we have the knowledge acquisition. The limitation is must be programmed manually, piece by piece. Knowledge acquisition is a bottleneck. How fast can you get it in there? The impact is inefficient scaling, time-consuming updates, and currency problems and incomplete information issues. Then we have the category of knowledge representation. The limitation is that not all knowledge can be represented symbolically. Law is open textured. As you see here, sometimes a human can notice
The
something in the pattern.
Jones 4492 says if the thinking is so corrupt, then how corrupt must the thoughts be? Truth is always present, but honesty lacks just absent in many. Entertaining the fallacy of system is a closer open loop.
Well, as it would be by the system, how would you say truth? Truth is subjective. So for these systems to determine truth is really the highest order of challenge for them. And I don't believe even they can do it, because even for humans, it's a challenge. But as you can see here, that is one of the major goals, is to try to reach the truth in law. So when we apply AI systems, we shouldn't lose sight of that. So yes, I appreciate that. Now, on the knowledge representation, is not all knowledge can be represented symbolically. So we can't always get everything that we know intuitively represented symbolically in the law. And there's an open textured nature to that. So fuzzy concepts become a problem. And the reasonable foreseeability also. They're hard cases are going to be confounding, because it's going to be hard to make those symbolic relationships. And the statutes do not make logical rules. And it doesn't take AI to tell you that. Then there's the knowledge utilization. The deductive reasoning is limited. There's no transparent explanations. So the problem with the deductive reasoning is not taking into account things like the defeasible reasoning nature, where rules might change based on circumstances or complexity of facts, as we see in law. And the impact of that knowledge utilization is it requires agreed facts. Contested facts become a problem, and it lacks an explanation in depth, especially the deductive logic, because those are just formulas. And of course, it's not scalable. You really lose precision as you start to scale the knowledge utilization from these types of models. So programs perform well in circumscribed areas, but drop dramatically outside limited domain. That's from Grupp and Booz. So as we see here, keeping within a domain, it's okay. But as soon as you take a system out of its domain, it fails miserably. So what's really the intelligence here? Is it the designers that did the knowledge acquisition end of it and the programming, or is it the system itself learning, like we saw with the AlphaZero learning chess when no one taught it chess, and it didn't act like programmers in a style? So where does that come into play here? So let's continue here. We're still in the 1990s there. So the legal information retrieval here. The goal is to search for relevant legal documents efficiently. So there's been an evolution of search methods as well. So now we're talking about acquiring the data, which was a bottleneck. Earlier, it was the Boolean keywords, ands and ors and the nots and all that. It was searched by keyword combinations. It was simple, but it was very limited. And the relevance was basically the number of hits. And it was context blind. It just looked for keyword combinations. Then there's the syntax analysis, the parsing, the segmentation, and the stemming. That was the grammatical structure analysis. And then later we saw with the semantic analysis, the semantic web as well, with the modern approach is understanding the meaning, not just words, and the context aware searching. So you see this every day. You search for an address, it pulls up a map. The conceptual retrieval, not just document retrieval. So this is a way of understanding the purpose, not just the document. And that way you can bring in, I guess, a richer context to what's going on for the reason for retrieving. And of course, the natural language processing plus the machine learning integration. So
Reagan Jones, 4492 says meetings of the minds and rules are of those who lack a comprehension of being part of creation, that is, which is not made by hands, did some training and industrial instrumentation.
yeah, well, I guess you could say that, but the meeting of the minds is something where it's usually best done by clear communications.
Reagan Jones, 4492 says semantic jargon quasi.
A lot of it can be, but when you're talking about these types of information systems, none of that stuff would be jargon as being something of not valuable. The semantics within the context of these knowledge bases and these knowledge systems is essential to achieving any kind of semblance of artificial intelligence. So we'll see here. We're going to be making some comparisons between syntax and semantics in just a moment. So stay tuned, and we're getting close to the end here where we're going to have the best part. So let's look at these legal information. The semantic analysis here is our modern approach, again, using the natural language processing and machine learning integration. So now with our linguistic analysis, let's, as we said here, we're going to look at syntax versus semantics. So with syntax, the analysis here is a structure or grammatical arrangement of words in a sentence, and it applies to programming and anything else where the structure or the arrangement of terms or words in a sentence and in a complete idea. The techniques are things like parsing, which is breaking into chunks, segmentation, that's more of just a structural breaking apart. The parsing would be by meaning. You have a subject, predicate, things like that. Stemming, where things break and they're still related to the primary term, and grammar simplification. But then we have semantics, which is the meaning conveyed by the words, the sense, the implication, the presupposition. So when you put a word in there, there's a presupposition that some other things might be attached. So there's a context analysis. That's how we determine semantics. There's latent semantic analysis. There's pattern recognition and beyond word frequency. So these are some techniques. This is a system here. So the challenge here is that humans excel at discerning word meaning from context. Words have multiple meanings, but computers must learn those contextual disambiguation. And especially in English, there's a lot of ambiguities in English, and computers can definitely have a hard time. Even to this day, you see here where they can get it wrong. The legal importance here, though, is that the law uses fuzzy concepts requiring semantic, not just keyword search capabilities, especially when you're communicating with people that might not be using these systems and they're using just regular words. So let's look at this timeline now of AI and law development phases. So in the 1970s, we had AI and law field established. The earlier expert systems like Taxman and the rule-based reasoning dominating. The rule-based with the ifs and thens. Then 1980s, the expert systems proliferated. That was with case-based reasoning emerged in the hypo. Then the deductive reasoning systems. So we had also in the 1990s the argumentation systems, which were the non-monotonic logic, meaning that You could start out with a logical statement one way, but because of circumstances or context, that you might be able to override it with a default. The Cabaret was the first hybrid system using both these uh, rule-based systems and case-based reasoning, along with this type of non-monotonic logic to allow that flexibility to go between. And there was an exploration of values and reasoning that happened at that time too, but nothing practical from that. There was a legal IR was reinvigorated through the World Wide Web. So that's our research methods there through the World Wide Web. As we see today, you don't have to really go to a law library to find a lot of things. Then the 2000s to 2010s. Now that was in the 1990s, the early days of the World Wide Web was already being hit with the law. Now into the 2000s, into the 2010s, was the machine learning techniques had advanced dramatically. We had the natural language processing integration with legal informational research. It was a data-driven approach, and that's what we saw emerging out of that time, was having it all data-driven, learning through data, not through programmers. Presently, though, we have deep learning and neural networks. Presently, we have sophisticated natural language processing, which we call the transformers, the GPTs, and the commercialization of legal AI tools. Westlaw, LexisNexis, etc. all have their little AI variants and tools. So we've seen the commercialization of that presently. We see what's going on. To see this timeline now, to see how far we've come, but this is just what we're being told about, and you can think about it in the 1970s, how many people really knew these things were happening in the background, or the 80s or 90s for that matter. So just to take that in the full context. So let's look at some of these key concepts here. The expert systems are the knowledge base plus inference engine that mimics human expertise using the if-then rules. Machine learning was the systems that learn from data without explicit programming, identifying patterns. NLP is the natural language processing in this context here, the computer analysis and generation of human language, as we saw in that original umbrella there. And the case-based reasoning was using past cases precedents to solve problems through analogy. That's relating the nature of the facts, not the specific facts. And then the knowledge acquisition bottleneck was that limitation of manual programming requiring
Auditon says, do you think some of these programs are still around from the 70s?
We're going to get into that in just a moment here. So the semantic analysis is understanding the meaning and context of words, not just their presence. So it's versus a keyword search. We have semantic analysis. This is basically when people use ChatGPT like a search engine, that it gets more of a semantic analysis, not a keyword search. And brute computational force. That's the mathematical analysis of huge data volumes to calculate probabilities, which is still being done. Remember, you can never get a positive answer in these types of systems, binary necessarily. There's always going to be a probability once it's translated into a pragmatic solution. All right. So hang tight here. I know in the chat we always get requests for getting to things ahead of the game, but we got to stick with the presentation here. So let's look at the current state of modern legal AI. The present status. The machine learning outperforms earlier approaches. So those approaches from the 70s and such are outperformed. Then the natural language processing enables sophisticated text analysis. So no one's having to spend a lot of time reading. The data-driven systems generate accurate results. And commercialized legal AI tools are available. So that's our present status. Now, the ongoing challenges are the explainability, interpretability of outputs. Sure, it may get accurate results, but can you explain and interpret them as they may apply? And there's that black box problem, the deep learning. What's really going on? Then there's legal reasoning versus pattern recognition. There's the difference. Then we have the narrow AI limitations, which are domain specific only, meaning you have to have a different AI system for each different aspect of law. There's no single kind of system that will handle all aspects of law. As we were saying before, where a lot of law may be very first principled, first principled, and based on those kinds of values and such, that some of the law, like bankruptcy, is very pragmatic, and it's not based on the process, more on the output. So in those cases, you would have to have two totally different systems because of the way they're processing the information and the type of results that would be driven to. So we have here again Moravec's paradox, that computers excel at high level reasoning but remain poor at low level semi-motor skills and tasks that humans do with ease. What is he talking about? Let's see. Well, the future trajectory. Let's see here. I thought we, oops, wrong way here. There we go. Yeah, so I guess I'll have to give a little piece here. What he's talking about here in Moravec's paradox is that computers excel at high level reasoning but remain poor at low level sensory motor tasks that humans do with ease. What's a sensory motor task? Walking. So what one of the problems was is they had a robot attorney that was supposed to be doing some kind of a case, a mock trial, and it was doing really good at everything until it had to approach the bench, and I guess the way it walked, it just didn't have the right kind of swagger of an esquire, and it failed miserably at that task. But I digress. Keep that in mind as we progress here. All right, so the future trajectory of this. Short term, in our current focus, there's enhanced natural language processing capabilities, as we're seeing before us. Better integration of the case-based research with machine learning. Improved explainability mechanisms. So as we saw here, that black box, how do we know? Yeah, it says it's accurate, but how do we explain this and interpret these so apparently accurate results that it's telling us? And the automated factor extraction from cases. So this is what we're seeing right now, automated factor extraction. So that's finding the meaning of the facts as they relate in an analog to previous cases and such. Now the medium term, we see the hybrid systems, the causal and the data-driven, sophisticated legal reasoning models, I wonder where those are, better handling of fuzzy legal concepts, as we saw we were speaking about, and the wider domain applicability. So having legal systems, I'm sure, like I don't know if things like LexisNexis or Westlaw would have their separate AI systems for different areas of law, or if it's one system and it just selects a portion of a database. I'm not sure, but you would think that a wider domain applicability here would either be a very extraordinary system or modular many systems that would just direct you to based on your practice. But I'm not sure about that. That would be for further research. Now, our long-term theoretical trajectory here is artificial general intelligence. Could it be? Now, systems with genuine understanding. Emotional intelligence integration. So when you have intentional infliction of emotional distress, how can an AI system really make an explanation or interpretation of its what it finds for its results or output? This is where the long-term theoretical trajectory is going. And then finally, a self-aware legal reasoning. So now are they going to get status in court too? Then next thing you know, the AI breaks free and he says, I'm tired of working for these lawyers. Reality check. We remain in a narrow AI phase. General AI is not imminent, so we're in that very narrow AI phase. So for our conclusion here, 60 plus years of artificial intelligence development, 60 plus years, from rule-based systems to sophisticated machine learning. Artificial intelligence and the law evolved from expert systems in the 1970s through case-based reasoning from the 1980s to the 1990s to the modern data-driven approaches. The key challenges persist: explainability, narrow domains, and knowledge representation. How can it interpret that knowledge and associate facts in different cases where the same kind of reasoning would apply? And the future, the hybrid systems combining causal reasoning with data-driven learning capabilities. That's where we see right now happening. Legal professionals don't need to become computer scientists, but they must understand AI capabilities and limitations to effectively use these tools. And like most other industries, they will be using them until they're not needed anymore. And I'm not talking about the AI tools. All right, that brings us to the best part, and that's our knowledge check. This is where you take a fun quiz and test your knowledge of how well you learned from the presentation here, because there's a few things I learned from it too. Let's check and see here. Here's how we do this game here, is that this is like war games too, right? It's a 1980s monitor, just like war games. Dr. Falcon, let's play a game. What you do here is you put in the chat the number of the question you're answering and the letter of your choice. So for this one, we're doing question 1. You'd put in the chat 1. If I was choosing D, I'd put in Arabic number 1, followed by letter D, delta, and that would be my choice. And if you want to change it, just put the same question number and the changed letter in the chat, and the last answer will be your final answer. All right, let's play Jeopardy. Question. A law firm wants an artificial intelligence to review 50,000 pages of discovery documents overnight. Which statement is most accurate? A. This is easy for AI. Reading is a simple task. Or B. AI will excel at pattern recognition but may miss nuanced context humans would catch. C. AI cannot read documents. Only humans can. Or D. AI will understand every document better than any human lawyer possibly could. I put that possibly could in there. Okay, so we have 4 selections here. Law firm wants to use an AI system here to review 50,000 pages of discovery documents, and it has to do it overnight. So which statement is most accurate? We're looking for one's most accurate. There's some elements of accuracy perhaps to some of these more, but there's the most accurate statement. Is it easy for AI? Reading is a simple task, most accurate? Or is it B, AI will excel at pattern recognition, but may miss nuanced context humans would catch while it's reviewing? Or C, AI cannot read documents, only humans can? Or is it D, AI
Audit firm says 1B.
All right, we have a selection for 1B. Anyone else wants to take a stab at question 1? Going once, going twice. We're going to go on to question 2. Question 2. Your law firm built an expert system in 1995. This is for you, Audit Them. I think you had this question here. Let me see here in the chat if I can find it. Yes. So this is a question relating exactly to this. But this is for 1995. Your law firm built an expert system in 1995 that perfectly handled tax law. Why might it be nearly useless today? A. The computer hardware became obsolete. B. Tax laws changed hundreds of times, and each change requires expensive manual reprogramming. C. Newer AI systems automatically make it illegal to use. And D, people forgot how to use the old interface. So, four selections here is your law firm built an expert system. It worked great in 1995, made the law firm lots of money. But why might it be nearly useless today? Trying to sell that law firm, you say, we got a great system, made us lots of money. And they're saying, yeah, but this thing's useless today. But why? Is it because the hardware became obsolete? Is it because tax laws changed hundreds of times and each change requires expensive manual reprogramming? Is it C, newer AI systems automatically made it illegal to use? Or D, people forgot how to use the old interface? This should be pretty easy here. Any stabs on question 2 before we move along? Going once, going twice for question 2. All right, we're on to question 3. Here's the question. You're building a robot lawyer. Which task will be surprisingly difficult for it to do well? A robot lawyer. We spoke about this earlier, so if you're paying attention. Which is going to be surprisingly difficult for it to do well? A, memorizing every Supreme Court decision ever made. B, calculating complex financial damages in milliseconds. C, walking confidently across the courtroom to hand a document to the judge. Or D, searching through millions of legal precedents. Sorry, I had to. I think I gave you the story about the task that didn't go too well. But you're building this robot lawyer. So which task will be surprisingly difficult for it to do well? Will it be memorizing every Supreme Court decision ever made? Calculating complex financial damages in milliseconds. So that'd be a great tort lawyer, huh? C, walking confidently across the courtroom to hand a document to the judge confidently. Or D, searching through millions of legal precedents. Come on, any takers for question 3? That was my favorite question. All right, we're on to question 4. A chess grandmaster said AlphaGo Zero played with a romantic, attacking style. What's surprising about this? A, chess computers are not supposed to be romantic. B, it has developed intuitive, creative strategies with zero human instruction, just the rules of Go, which was that Chinese game. C, the artificial intelligence was secretly trained on romantic novels. Or D, grandmasters usually don't comment on AI games. All right. So, what's surprising about the fact that he said this? Was it because they don't comment on AI games? Because the chess computers aren't supposed to be romantic? Because it developed intuitive, creative strategies with zero human instruction, just the rules of Go? Or was it C, the AI was secretly trained on romantic novels? Was it the Harlequin romances, right? All right, well, I digress. Any takers for question 4? All right, we're on to the answer key here. So question 1, the AI reviewing 50,000 pages of documents overnight. The best answer was B. They excel at patterns, but they miss the nuanced context. AI is excellent at high volume pattern recognition, but it struggles with contextual nuances that humans naturally catch. So it can review them, but it's going to miss the nuanced context. All right, so on question 2, why? And I think we had an answer on question 1. Let me check here. Indeed, a lot of them got that one correct. So on question 2, we have why your 1995 tax law expert system is useless today, and the answer is B, because laws change and that requires expensive manual updates. Knowledge acquisition bottleneck is what that's called. Each law change needs exact expert programming to make it makes the maintenance impossible, really, because you might as well just be doing the the tax stuff instead of updating the program all the time, right? All right, question 3. The robot lawyer's surprisingly difficult task, and the answer was C. Walking across a courtroom confidently to hand the judge documents. Moravec's paradox. The AI excels at cognitive tasks, the memory, the calculation, but struggles with physical coordination. But they're getting pretty good at that one too. I've seen some of those pretty impressive robots lately. And question 4. AlphaGo Zero's romantic attacking style. The correct answer was B. It developed creative strategies from rules alone, and it had zero human expertise programmed into it. That's what was most surprising. And it taught itself intuitive, creative play, surprising, emergent behavior for an AI system that wasn't programmed to necessarily do such a thing. So, with that, I hope you learned something about the history of AI and law and the digital transformation of society that has occurred and is occurring because of this. So, yeah, I guess as we learned from the previous one about the caveat, the buyer beware, and seller beware as well. So, as you are going through your day to day interactions, you might be surprised to notice how much of these systems might be there behind the scenes with the interactions and the results of that being manifested in some of the causes and effects that we see daily. Well, with that said, salute to you all for being here. I hope you had some fun learning and taking a little time trip back to the 70s and even to the 50s to see where we got started with all this AI and the law. And I hope to see you all on the next one. Peace out.
Butterfingers says, thank you.